Can they enforce new guidelines on everyone? Board of directors can amend guidelines unilaterally, but we'll get into that a little bit more. No membership vote is required. Committee cannot change guidelines, only a board can. That's important too, because the committee could be different than the board. Changes must be distributed to all owners.
Again, that's the notice requirement. And there's often a period of time where the community can speak up. I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson. Welcome back to Bad HOA. Marty, welcome.
Thank you. It's good to be back in the flow here again.
Yeah, it feels good. And you told me a very interesting statistic about how many episodes we've done so far.
Yeah.
And that number was 39.
39.
That's incredible.
Of just Bad HOA. I mean, we did the LS Carlson podcast. We've done the empowerment sessions. We've also done a lot of short form videos. So yeah, it's fun that we're on the crest of number 40 here. We'll have to when we hit 50, we'll do some sort of like,
maybe celebratory.
Like
something.
in Seinfeld, it's the 100th episode, and
Yeah.
it's always disappointing though. That's the problem. They do clips of all of the past episodes of like the greatest hits, and I was always irritated by that. I'm like, just give me a new episode.
Well, maybe we'll try to overperform on the 50th.
Okay. We'll just bring, instead of in these mugs of being sparkling water, we'll actually use coffee.
Okay.
To juice it up. Yeah.
I like that.
Be off the rails.
Some rocket fuel for the show. Okay, episode 39. And the space is the gift that keeps giving because it's almost endless. There's so many aspects of bad HOAs that you can look at, dissect, and really determine, okay, how can we empower homeowners to tackle various issues that arise? So this one is the architectural control committees and really the problems or how these things go south.
You know what was the most shocking thing about this episode topic?
What's that?
That we haven't covered it. Like sometimes I think I'm like, are we ever going to run out of content? And we just keep churning. There's always something new.
Well, like I said, it's
cover.
sort of endless.
I know.
There's so many aspects of a community, and like I said, so many things can go wrong. And this is such a big topic. When things go off the track, it's very common it comes from the Architectural Control Committee, etc.
There's a lot of layers on this one.
Yeah.
And what's funny is that this is, when anyone thinks about HOA, this is what they think about. They think, what
a flashpoint?
Yeah, what color can't I paint my home?
Right.
What? The HOA didn't let me put in that grass or whatever. It's always has to do with this particular topic. So,
well, because you can see it strikes as such a petty issue.
It totally does.
You have the board president who's the tyrant or whomever, the meddler, and they're holding up a shade of gray, and your shade's a little bit off, and then all of a sudden you get violation. It becomes a big issue.
Yeah.
It's a flashpoint.
You're right. It does seem petty in many senses.
Or that's where like the garden gnomes, no garden gnomes, and they remove the garden gnomes from the front property, right? This is
gnomes.
all in this universe of architectural control.
Yeah. Yep.
So let's dive right in.
Okay.
All right.
Let's start with where the power comes from, because I don't think that's evident. So I think it's always worth laying a foundation of where the power comes from.
The power source for these.
Yeah, the power source for this, as well as the reason that they're kind of put in place, and then the legal definition. So I want to just kind of set the stage here. Then as we go on, as always, we'll say how to approach it without needing a lawyer. And then also, what are the red flags to bring one on? So we'll jump into it. So where the power comes from. Yeah. Let's jump into it.
So, like any association, we always talk about this. You have the governing documents.
Yes.
Right? Those are the CC&Rs, the bylaws.
Yes.
And those are recorded. What's interesting about architectural control, the rules and regulations, though, often it comes subsequent to. So a community is developed, you have the CC&Rs, and the board comes together and starts setting these community standards. And those are typically not recorded. Right?
Yeah. So that's a really interesting point, because There could be some in the CC&Rs and some that are split and say it's an entirely different document. And sometimes the CC&Rs will refer to said
right. And those evolve over time too.
Yeah.
And so there might be amendments, there might be addendums. And so what's interesting, being in this space for so long, you see these Frankenstein documents. And you see, okay, in 1983, they set them up. Then 10 years later, they changed them and modified them. They go into a different direction, and then they do that again. And then all of a sudden, though, the most recent are in conflict with something.
Sure.
Right? And that creates ambiguity. And that's really a discretionary point that causes a lot of problems.
Yes.
Because, right, if you have a board and they're trying to decode this and they think it's one way, but in reality, you have a legal argument, or at least an argument based upon the rules and regulations as written, it's a conflict. So who's right, who's wrong?
Yeah, because I think so many people think like, well, this isn't the law, right? When it comes to CC&Rs, but they're enforceable. Like that is the CC&Rs are recorded. Is it by the county or is it by the city?
County.
The county, which is interesting because it's like, oh, well, this is a legally binding document, just like any like corporate docs or contracts.
Right. And they're enforceable both ways.
Yes.
So when you have that rogue board who's enforcing in a way that's inconsistent, that becomes a violation of those documents.
Yes. Okay, so let's jump into a couple of examples here.
Okay.
And I think it's fun to just kind of lay it out of what guidelines.
Regulate?
Yeah, and then
What's the domain?
and then some extreme examples of that too. So I'll rattle some off.
Okay.
Exterior paint colors, right?
That's the big one. Yeah.
Roofing, material types, color, manufacturer, brand requirements, fencing, height, material, color, style, setbacks, landscaping with plant types, tree height, limits, grass, hardscape percentage, mulch color, windows, the style, single hung versus casement, grid pattern, etc. Front door colors. And it says a little note, may require approval even for repainting the same color. Pretty wild.
Sometimes,
okay.
yeah.
Driveway materials, holiday decorations, mailboxes, house numbers. I mean, imagine like this font is approved, this font is not approved.
And that happens all the time.
Yeah. Satellite dishes, solar panels, AC units, play equipment, outdoor furniture, basketball hoops, gutters, security cameras, and outdoor lighting. So
virtually anything you can see could fall under the domain of an architectural control committee.
And I've seen it many times where even something in your backyard that's visible, like a shed,
possibly from the street.
Shed, that's visible from the street, is in their purview.
Right. If you look at it, it's really a visibility thing.
Yes.
And if you go back out, what is the utility of all of this? Well, you're trying to establish some sort of harmony, community standards. It's harmonious. You don't have situations where there's holiday lights up in June.
Yeah. Well, I think that's an important distinction. A lot of people, what draws you to an HOA in the first place? It's usually the aesthetics
of not only the home though, but the one that you're going to purchase, but the other homes.
100%.
Right? It's the neighborhood. How well is it kept? Is it
right?
You don't necessarily want to live next to a zebra painted house.
Yeah, I mean, you can't.
I mean, no offense to people who do. I'm sure some people do, but my point is, if that happens, it may very well depreciate your fair market value.
Right. I mean, so I think it's important, as much as people say, I'm so constrained by this, but this is possibly the reason that you ended up in the first place. What makes them so nice.
It has utility.
Yes, it does have utility.
When, with the caveat, when appropriately applied.
Yes.
And the standards are consistent, which we'll get into.
Yes. Let's give some extreme examples because those are just fun. Okay. Specific shades of off-white required for all houses. No visible hose reels, trash cans, or pool equipment from the street or visible from the street. All garage doors must remain closed except when entering or exiting. Landscaping rocks must be earth-toned river rock, not white decorative stone. All front yard plants must be approved list, may be 5 to 10 species only. Patio furniture cushions must be solid colors, no patterns.
Mm-hmm.
No American flags larger than specific dimensions limited by federal law.
Right. So it can get very nitty gritty very quickly. Yeah, straight up to the stone, the type of stone, the color of the stone, the placement of the stone. In theory, can be controlled.
Yep. All right. So let's talk a little bit about California law and some key distinctions here. CC&Rs require owner vote to amend percentage specified in CC&Rs or if silent majority of all members. So that kind of laying the foundation here, right? The guidelines or operating rules. Boards can change them without owner vote. There's a civil code in there, 4340. Guidelines must be, one, reasonable. Two, cannot contradict CC&Rs. That's civil code 4350. C and E. For people that want to look this up, at least in California, this is all
California-based.
Yes. Distribution required. Boards must give at least 28 days notice before changing guidelines, Civil Code 4360.
And that's a big one because quite often when these disputes arise, it's because there wasn't proper notice.
Yeah.
And so that's so important to sort of track that. If there are changes to, one, be notified. And if you're not notified and you're getting hit with a violation that came out of thin air, you want to start unpacking that timeline.
Yeah.
So that's actually a very big code section.
Yeah. Okay, so who has the power to change guidelines? Board of directors can amend guidelines unilaterally. Well, we'll get into that a little bit more. No membership vote is required. Committee cannot change guidelines. Only a board can. That's important too, because the committee could be different than the board. And then changes must be distributed to all owners.
Again, that's the notice requirement. And there's often a period of time where the community can speak up.
Yeah. Yeah. We'll get into that. Like in particular, we're just hitting the bullet points here. Can they enforce new guidelines on everyone? So let's hit the bullet points real quick. Yes, a board has authority to update guidelines. New guidelines apply to all future applications. Existing approved projects are generally grandfathered. I think that's so important.
Well, you see that quite frequently. Yeah. There's certain communities that at one point allowed for pools. I see that a lot. That's a flashpoint. Yeah, a lot of people have pools, and then at some point they realize maybe for liability purposes or there's some reason as to why moving forward there's no more pool approval.
Yeah.
Obviously, they don't expect everyone to rip out their pools.
Yep.
Right? And that's a clear example of when these things get grandfathered in.
Well, I think too a very small, like a much more toned down version of that would be you bought a house that was built in the 80s and those peach colored everything is now no longer in vogue.
Right.
Right. And the homeowners and like the whole neighborhood is calling for some updates to the paint palettes and maybe some of the other things. So that could, present it, but they can't just say everyone has to change their color to the most in vogue. Like,
how that harmonizes or stabilizes though is at some point your peach paint is going to start chipping or fading.
Yes.
Right. And at that point you have to, normally most HOAs require some sort of submission or application.
Yes.
Hey, I want to paint the house. Now, if you go back and say, hey, I want to paint it peach again, you may very well be barred.
Yeah.
And they say, well, we have new standards and now these new standards apply.
Yeah.
Because you have to paint your house anyway.
Yeah.
So that's how these things sort of harmonize throughout a community when it comes to paint.
Yeah.
Not necessarily to pools, obviously, but paint.
Two more bullet points that I want to hit, and then we're gonna dive deeper. Guidelines cannot exceed restrictions in CC&Rs, which is an important distinction because we just said that the guidelines can be separate from the CC&Rs, but if they change the guidelines, which they don't need approval by the homeowners, then they're in conflict with the CC&Rs trump
Control.
The guidelines cannot be in conflict. The second part of that is guidelines must be reasonable under California law. That's a tripwire.
That's a
tripwire for sure.
And we'll get, I know we're going to get into that, but there's an interesting comment I saw on a previous video and really harping on the fact that, state law at the end of the day will trump CC&Rs, which will trump rules and regulations.
Yep.
So we'll discuss that. And there's very specific carve out, especially in California.
Yep.
So.
Yep. Okay. So what happens when guidelines conflict with state law? State law wins always. And then I think that I want to hit on a couple points. State law had changed recently, even since we've been doing this podcast, a few different times where solar now is approved. Now that could be in complete conflict with CC&Rs and or architectural guidelines, which means that they are no longer valid. Right? The drought tolerant landscape, that was a big one. That's in California law as well. And then like the EV charging stations.
Which we spoke about.
We just talked about last week. Shameless plug for the 2026 California laws episode.
Yep, exactly.
Okay. So If those guidelines are conflicting with state laws, they become unenforceable. Committee must approve projects protected by state law. I mean, we've said it.
And what you identified are the big buckets, right? And those are the hot topics. And when you look at history and how this has played out, especially when the whole drought tolerant plants came into play, you had so many HOAs really enforcing, hey, this needs to be a green belt. It needs to have a lawn. And homeowners were able to push back very effectively. Yeah. And often it was a misinformed board. They didn't understand the relationship between the CC&Rs and state law. Yeah. And so, but those conflicts come up all the time, especially with solar. Solar's a big one.
Because a lot of the times those panels could be forward facing that you could see from the street.
Correct. Now they're permitted, the HOA is permitted to make some requests and adjustments, but it has to follow certain constraints. Yeah. And so it's not carte blanche. And a lot of HOAs that I've seen have approached it in terms of a carte blanche, no solar, put your solar here. Homeowners can push back. Yeah. On obviously state law trumps.
Yep. All right. Let's jump into how the inconsistencies happen. Okay. So let's hit a couple bullet points here. So let's talk about the common ones. So committee membership rotates. Different people, different judgment. I think it's worth noting that a lot of this stuff is somewhat subjective too. I mean, if these things are written with some ambiguity, then
it's typically over the ambiguity.
Yes.
Right?
Yes.
It's poor wordsmithing at the end of the day.
So here's an example, right? The next one. Guidelines use subjective language like aesthetically pleasing or harmonious. Right. Like that is so subjective.
It can be a throwaway word, but that type of word is a tripwire for a dispute.
Yeah. I hate that though. You know what I mean? Like I kind of get it because to some extent, like you want to have some flexibility to like maybe move the needle at a certain point. Like I was saying, the 80s peach houses that might need to change. So I can kind of see why originally it's written with some
flexibility can work very well, assuming you have a really good board. It's when you have a bad HOA, and we've talked about the personality types, but a tyrant type will leverage that ambiguity. Yeah. A meddler might do the same thing. An incompetent may have no idea that there even is an ambiguity, right? So that's where you get these windows of abuse of these types of rules and regulations.
Yeah, yeah. Okay, so the other thing was prior approvals are not well documented. So I think that's showing precedent. But like, okay, I mean, but I guess we can both be right.
Really, it's competence. That's what that is.
No institutional memory of past decisions.
Right. Bad bookkeeping. At the end of the day, that's bad record keeping.
Yeah. Incomplete applications make comparison impossible. So same. Yeah. Just bad record keeping. Okay. Let's use some real world examples of these inconsistencies. Neighbor's pergola is approved. Neighbor's pergola of 8 by 12 is approved. Yours 8 by 10 is denied as too large. 3 houses on the street have gray front doors. Committee says gray doesn't match the neighborhood. Drought tolerant landscaping approved in 2022, denied in 24. Different committee. Paint color accessible beige approved for one house, but called too tan for another. Fence approved at 6 feet on corner lot, denied at 6 feet on interior lot with no written distinction. Solar panels approved on street-facing roof in 23, denied in 24 after committee change. Right. Artificial turf approved for 4 houses, denied on the 5th as not looking natural. Right. I mean, it's interesting for sure.
Well, those examples, from a homeowner's perspective, if you're denied and it is so clear that other homeowners have sort of standards that are consistent with yours, but you got denied, that's where you start to look at, okay, the community, how this is being applied. And some of the more blatant examples lend themselves sort of the best for documentation and enforcing your rights against a bad HOA. Yeah. Because some of these are so clear. It's like, hey, I have the exact same color as my neighbor and the neighbor's right there. Yeah. That's very helpful from an evidentiary standpoint.
Yeah. I think if I remember correct, in the HOA that I was in, our house had to be a certain color because you didn't want like 5 gray houses in a row. Right. It's like, no, yours, they could be gray yours cannot. Yours has to be this particular color,
Right.
Because it goes back to like the harmonious thing.
Right.
I do remember that being an issue. I think the color of my fence and my backyard fence became an issue.
Well, it all can become an issue, right? I mean, at the end of the day.
Okay. So when it becomes a problem, some projects are approved for some, denied for you. Committee applies rules that aren't written anywhere. Denials seem targeted or personal. Committee exceeds its authority under the CC&Rs. Approval given, then revoked after you start work. That's brutal. That's really brutal. And then we talk about it. We don't like it. Becomes the standard instead of written guidelines.
Yeah, and there's a lot to unpack on that in and of itself, because there's this notion of reliance, and this is a big one, and it can sort of cut in various ways. But that's where an HOA says, "Yeah, go ahead with your big project, build a patio, build it." You start putting a lot of money into it. You have an email, you have sort of correspondence that confirm that you got the approval, and then as you're halfway in, they try to shut you down. But you relied upon their representation.
Yeah.
Right? So that becomes, in and of itself, these massive disputes, because you've already poured money, you've invested money into a project, you seemingly got the approval, and the board says, well, you didn't do it our way or the right way, or one of the board members spoke out of turn. That's actually quite common.
Because do they in typical format, do they have to vote on it? Like the committee?
It depends. I mean, there's various ways that these are sort of reviewed.
Okay.
And there's some HOAs that just have one person who reviews all of them. Other times they have a committee. Sometimes the committee is different than the board. So it just sort of depends on the DNA of that community. But, in situations where someone goes rogue or a board president is chummy with somebody, says, yeah, go ahead.
Yeah.
These cause a lot of problems.
Yeah.
When we can get into it, but, at the end of the day, everything has to be in writing, which we've harped upon so many times. But I've seen situations where the board president will say, hey, Joe, don't even worry about it. Build your patio. You don't need to go through the Architectural Control Committee. And then the Architectural Control Committee says, BS, you have to, and tries to shut it down after they got the reliance upon the president.
Yeah, so that's a really good point. So president might have said yes, but the Architectural Control Committee then denies.
It says no subsequent to, once the work has started. Or you get that with a management company. You reach out to a management company and say, I want to build this patio, and this is so important. Here's what it's going to look like. Management company wrongfully says, yeah, don't even worry about it. Move ahead. You don't have to bring this to the Architectural Control Committee. So now the homeowner relies upon that representation. And you can see where these disputes arise, right? I mean, it's a hotbed for that sort of, those types of problems.
Yeah. Let's talk about what's legal versus illegal, at least here in California. What committees can do, right? So let's talk about board discretion. Apply subjective, so this is can apply subjective aesthetic standards of harmonious, compatible, or appropriate. Well, I know a lot of people probably don't want to hear it.
Well, there's always going to be a level of subjectivity to the space when we're dealing with aesthetics.
Well, and it falls back to California, again, says reasonable.
Right.
Like they say harmonious, compatible, and appropriate, but are those reasonable? Like, is it reasonable?
Well, you also got to play the tape all the way to sort of the bitter end. And in California, you have the business judgment rule. And what the courts are saying is we're not going to micromanage the decisions of a board. Okay? So let's say a homeowner says, you know what, this is BS, this is unreasonable, I disagree with the committee. And they go through the ADR process, they end up filing a lawsuit, and it gets before a judge or a jury. They're not going to say, they don't want to micromanage, well, I think that this is harmonious or not harmonious. Deference will typically be given to the HOA. And ultimately, what you're going to have to show is really hard sort of injustice in the sense of this was selective enforcement or preferential treatment, or we've used the Architectural Control Committee as a form to harass you. You're being treated differently than others. And ultimately, that's really the standard that we often look at when cases come through, especially when it comes to this category of dispute.
So you think, so most of the disputes that you see are selective enforcement. Like that's the arm, that's the legal arm of which you're going to pull the lever.
Majority, yeah. So it's a selective enforcement, preferential treatment. In a unequal application of the rules. That's very common.
Yeah.
Or again, preferential treatment's a big one. The board president was able to do this. The secretary was able to do this. I've been denied. Or technicalities. Hey, we submitted our architectural application. There's a certain window where they can deny it or approve it. They did neither. They were silent. The rules say after a certain amount of time, if we don't say anything, it's approved. We move forward with it, and they say, oh, we inadvertently didn't respond to it. We're so sorry, you're denied. So there's a whole bunch of reasons as to why these hit our desk, but often it's in that vein.
Got it. Interesting. Okay, so I'll keep going. The board discretion. Deny projects that are technically comply with the guidelines, but committee finds unattractive. Interpret vague language differently over time. Treat similar projects differently if they can articulate legitimate distinctions. Require specific brands or materials if guidelines authorize it. They've got control. Like there's some areas.
There's no question when you buy into an HOA, you're giving up control.
Yeah,
to some extent.
Yep. Okay, so where does the I think it's pretty. We went through examples of this, but let's get to their authority. Enforce the CC&R. Their authority comes from the CC&Rs. They can apply board approved guidelines, require detailed applications, condition approval on modifications, or deny non-compliant projects.
Right.
Okay, so let's talk about what they can't do. Exceeding authority. So apply restrictions not in the CC&Rs or guidelines.
And you see this quite frequently where they will enforce a standard that just doesn't exist. Or they'll try to say, let's use the rock example because that's always a little bit absurd, right? And they say, hey, this is the wrong shade of rock.
Yeah.
Then you push back. You say, well, show me the authority on that. Well, we just don't like it.
Yeah.
Well, you typically have to anchor it to some sort of rule, regulation, CC&R.
Yep.
And that's where these HOAs, in my opinion, are overreaching. When they can't anchor it to their legal authority.
Yeah. Deny fully compliant projects arbitrarily. I mean...
Yeah, that's where, Susie down the street got her project approved. You have the same project and yours was denied.
And they have nothing to anchor
No
it
backing. And you even say, well, Susie has this, and they shut you down still.
Yep. Enforce personal preferences as rules. I mean, it goes back to they can't apply restrictions that don't exist.
Well, that one flares up too. I've seen it typically where a board member, their house is, next to another house. And that house is seeking some sort of application for something. And the board member doesn't like it because it impacts their house in some way, shape, or form, even though under the CC&Rs, the rules and regulations, it's permitted.
Allow for it.
So it's a personal sort of situation.
So the committee cannot create new rules. Only a board can do this. That's an interesting one as well.
Well, when we talk about committees, though, committees operate sort of outside of the actual board. It's sort of an arm of the board.
Yeah.
Right? The board was voted into power.
Yes.
Committees, often, though, the committee and the boards are one and the same.
Yeah.
So what they'll say is like, okay, we have an architectural control committee meeting, and 3 of the board members go and have that meeting.
Those responsibilities ever get pushed to, let's say, a property management company?
Interesting. I have not seen that.
But I guess the point is not to say like going to the property management, but those responsibilities can get pushed outside of the board. I guess is
yeah, but it's always under the board's purview at the end of the day.
But that's the same thing. If their property management screws up, it's still at the end of the day the buck stops with the board.
With the board, yeah.
Okay. So the other thing that obviously the California law violations in regards to this would be act arbitrarily or capriciously. That would be California Civil Code 4350. Selectively enforce to discriminate, violate fair housing laws, ignore required procedures in government documents, or apply restrictions that conflict with state law. So I think that kind of gives you the California legal...
What's the bright line?
Yeah. Okay. So an anchor to this entire show has always been handling it yourself.
Yep. Which is the empowerment side of this.
Yes. And I think, we'll get into some of this, from a high level, but we did another entire episode on the strike method, which is kind of our framework on our go-to framework. A whole episode on that. Definitely worth the read or listen. And then we have a little sheet that's available for that as well.
Right.
And for those that really want to dive deep, that want to kind of take these disputes on themselves, the empowerment kit.
The empowerment kit lends itself beautifully to these types of disputes.
Yep. Again, that's an entire framework on how to handle the handle dispute on your own. Another episode and a lot of supplemental materials. Also, all this is
And maybe
available.
we can link it to this one.
Yeah, we will.
Because at the end of the day, the strike method, the empowerment kit really comes into play, especially if you're looking to take this on without a lawyer to start.
Yep. Yeah, and then we do have it on it's all on our Reddit as well. If say you can't find it for whatever reason, just go search for it. It's on Reddit.
Subreddit,
on our
at
subreddit.
HOA.
That's it. Okay. Handling it yourself. So I guess the number one thing is do your homework.
Yeah. Well, okay. So yeah, let's dive into this. So, and maybe if we come up with a hypothetical, it's an easier way to approach this.
Yep.
So let's say you were denied a patio.
Okay.
Okay. Just flat out denied. So the starting point really is, I would say the fundamental question is, did you as the homeowner follow the procedure? Did you properly submit the information to the board?
Yeah. Okay. Let me ask you this.
Yeah.
Do the CC&Rs or bylaws have any sort of procedures that outline these types of things, like the request for architectural changes?
Yeah, normally you would find them in the CC&Rs, but if they're not in the CC&Rs, they're going to be in the spin-off documents, which
Yes.
are often the architectural rules and procedures.
Yes.
So there's a booklet on that specifically. It's typically carved out of the CC&Rs.
Yep.
CC&Rs gives the authority to do it. And in that, there should be very clear guidelines in terms of how to submit a project.
Okay.
And if there's not, the recommendation is just ask the board directly.
In writing.
In writing, of course. Nothing verbal. So did you follow procedure?
Yeah.
And assuming you did, right?
Yeah.
Then the question becomes, okay, what was the basis of the denial? And
Yeah.
then that's how you start working it back into the CC&Rs. And once you look at that, and let's assume for a second that it's very clear that your patio was 100% authorized. You followed the procedures. Their denial was arbitrary and capricious, meaning it's just denied for no reason.
Yep.
And there's other homes with the exact same patio. Okay?
Yep.
So this becomes a big problem.
Yep.
So how do you approach it from a homeowner's perspective? So one, you can fall on the sword and give up, which I don't recommend. Even though, I understand the frustration.
Yeah.
But I would start this, or I'd recommend starting this with an IDR. And we've discussed that before under, California law. The homeowner has a right to demand informal dispute resolution.
Yeah.
IDR. It's typically a request sent via email. That's pretty straightforward.
Yeah.
And it's an attempt to sit down with the board, discuss the project, and sort of walk through the logic or lack thereof of why this was denied.
Yeah.
Now, there can be an appeal process attached to the Architectural Control Committee's denial. That might be another way of doing it. But whether it's IDR or the appeals process, the point is get in front of the board, have that conversation.
Yeah.
Let them sort of answer you directly. And now, especially if you show up at that meeting with evidence.
Yep.
This is Unit 3, Unit 7, Unit 10, all have the same patio. Mine is virtually identical. What is the basis? You didn't cite a basis.
Yeah.
Put them on their heels a bit.
Yeah. I mean, to your point, the denial should be anchored to something.
Correct.
Like it should either, there's something that should be cited, right? On why it was denied.
Correct. And it's typically a red flag when there's no reason as to why it was denied.
Yeah. I'm assuming you've seen this, and this is probably even gets spicier, is when, let's just say the committee of 10 years ago is approving fences that are 8 feet tall. And everyone kind of gets 8 feet tall, 8 feet tall, 8 feet tall. And then all of a sudden, committee kind of switches over, and then you're like, I want a larger fence, and you get approved. Like you say, I'm requested for this fence, it's 8 feet tall. And like, actually, the rules say the guidelines here are that they're actually 6 feet tall, but they've approved it, even though the documentation says you can't have them 8 feet tall. I assume that's where it gets real spicy real quick.
Well, new committees, new boards are able to start enforcing more strictly. Okay. And if that wasn't the case, it seems to me that there would be a big problem in HOA land. Because if you got a really sloppy board that's a really bad sort of history in the community, then you'd be in a tough position to get back to the CC&Rs and back to the rules and regulations, right? So often, so long as those new rules and new board, let's say, is applying standards equally. So it's not arbitrary and capricious, meaning you don't get 8, but you get 8, but you get 6, you have to have 6. But
yes.
That would be a problem. But if it was a carte blanche, hey, everyone now has to go back to 6.
Yes.
It's likely going to be enforceable.
But that's the same basic logic, though, which is if those were amended and they weren't in the CC&Rs and they decide the board votes to make those changes, just like we talked about the paint color, then everyone from here on out needs to if you need your fence replaced, it needs to be 6 feet.
Right.
We changed it.
And that's typically how you'd see that play out in real life.
Yeah. Makes sense. In that case too, if all the 8 feet, would you, in many cases, do you see the board just amending it at that point or just enforcing it at that point?
It depends. It depends on the board, right?
Yeah.
I can see it both ways.
Yeah. Okay. So we talked a little bit. Okay. So photograph, walk the neighborhood, document what's there. I mean, this is so important, but read the CC&Rs. I mean, we talk about education, read your CC&Rs because they cannot be in conflict with those guidelines. The CC&Rs, they're just like federal law trumps California law. They cannot be in conflict. So if the guidelines that they pass are now in conflict with those, the CC&R kind of trumps it. So I guess number one is read your CC&Rs.
Get familiar with the CC&Rs, and most CC&Rs that I've seen historically, though, are somewhat vague and ambiguous when it comes to very specific guidelines.
Yeah.
Again, those guidelines are typically carved out in a secondary document.
Yeah.
So,
and then state law. I mean, that's the other thing is that we just had this year as of January 1st changes to some of the EV restrictions, right? And the chargers that could throw a lot of some of this stuff out the door.
Yeah.
So get familiar.
And that goes to the bigger buckets. Those are public policy issues. We want to encourage solar, electric cars,
drought tolerant
plants, right?
Yep.
These are all public policy issues.
Yeah, read your CC&Rs, submit everything with detailed plans and thoroughly in the guideline, in the way that the guidelines specify.
Precisely, yes.
Get everything in writing, no verbal approval, and make sure it goes to the right people. Just because a board member X says you can do it does not mean that's the proper procedure.
Right, and let's say you get it. Let's say you get a verbal approval.
Yeah.
Put it in writing, confirm with everybody.
Yeah.
Just avoid the issue altogether. Before you start throwing money at a project, get it in writing, confirm it in writing, get it in front of everybody.
Yep. I guess we talked about a little bit if it's denied. So step one is ask for specific citations. Which guidelines does this violate? How is this different from neighbor X? Get committee meeting minutes if possible. Ask for what modifications would make it approvable. I think that's a great point too.
Yeah, and often, when you're dealing with a good board or a good architectural control committee, they'll actually walk you through it.
Yeah.
They'll say, hey, your patio was actually not consistent with the other patios, and here's why.
Yep.
There's a different material, or you used a different aesthetic, and this is the aesthetic that we would approve and give you sort of a second bite at that apple.
Yeah. What are your thoughts on if the committee denies appealing to the board?
In what sense? I mean,
okay, you got yours denied and you thought it was pretty clear cut, but they're kind of using a little bit of discretion, right? Maybe it's a little bit ambiguous. Like it says they denied your shade of gray, even though it said it could be gray.
Well, when we talk about the word appeal, though, there's typically an appeals process within the architectural control committee world.
I got it.
Now, what I'm saying is if you were denied, you may want to run that appeals process first. If you get shut down there, then you may want to flip it entirely over to an IDR, which would be with the board.
Okay, with the board. Okay, so that is, to some extent, the next layer would be if you get denied on something specific. And there's no grounds. Like, I think that if they deny it and there's grounds there, it's hard to, don't beat the dead horse.
Yeah, and also, too, you have to remember, if, let's say you were denied, and it was a hard denial, and you know why it was, and it was because so-and-so was on the board, and they really don't like you, and you know that the appeals process would be nothing more than sort of a performative sort of, rigmarole, right? That's not going to go anywhere. you may want to short circuit that entirely and run the IDR. If you know unequivocally you're going to get denied. And you can actually bring that issue up with the IDR at the IDR.
Yeah.
Say, hey, so-and-so's on the board. They don't like me. Here's the evidence that everyone else has this same, sort of patio. Let's use the patio example. And so-and-so did not articulate why it was denied. Here's everyone, again, who's using the same material, the same aesthetic. Everything is consistent with what I did. Yeah. I'm not going to appeal this because I know I'm just going to get shut down again.
Yeah.
That might be a strategic way to use the IDR process.
Yeah. I think though too, I think it's worth mentioning for homeowners, if it's clear cut and they deny you and you're just trying to get one through because you want it badly, you did sign up for the HOA. You know what I mean? Like if you're saying, I want my house to be painted X and they say, no, it does not follow the guidelines, and you just say, I'm going to the board, and you try to use all these tactics, it's still at the end of the day, you're kind of just shooting yourself in the foot.
You have to look at more than just, you just want this. Let's use the zebra example. Yeah. Zebra paint. You're probably not going to get it in most communities.
Yeah.
All the other houses are zebra.
Yeah.
Or you have a very, very loose HOA that doesn't care. That's not enforcing any of the CC&Rs, and you have a polka dot house, and you have all these crazy looking houses.
That goes back to the same problem that we have, is that then at what point does it? I think both are obviously an issue. The HOAs that don't enforce,
because that in and of itself becomes its own issue of breach of fiduciary, violation of CC&Rs, and so it cuts in a lot of different ways.
Right, and then now your fair market value. I mean, there's a lot of things now associated with it by your HOA approving or not enforcing. Right. I guess approval and not enforcing are two separate issues, right? If they're not enforcing, then the neighborhood could get out of control quickly, which will potentially affect your fair market value at the end of the day. And then to wind that back I could see how it becomes nearly impossible. So for you to try to sneak one past them, maybe you've won the battle, but you could lose the war if the war is your fair market value.
Correct. Yeah.
Okay. Let's go to red flags for an attorney. When to bring on legal help. Why don't you spearhead this one?
Yeah. So let's go back to the scenario where you go through the appeals process, you follow the rules, and you cross your T's, dot your I's.
Yeah.
And you're denied again.
Yeah.
Okay. Then you say, well, now let me flip it over to the IDR. You go to the informal dispute resolution meeting. You're at the clubhouse. You lay out your evidence. Maybe you use the empowerment kit.
Yeah.
Right. So it's laid out in a very clinical, methodical way, and the board just shuts you down.
Yep.
Even though 4 or 5 other neighbors' houses have the exact same thing. At that point, I would argue that legal or attorney intervention might be required if it's important to you.
Yeah.
And it could be, because let's say the patio adds a lot of fair market value, or it increases the enjoyment of your house, and it's an important thing, right? Yeah. And you're being shut down unfairly. It seems arbitrary, capricious. So at that point, you go to a lawyer, and I would say the lawyer should be able to run an analysis to determine whether or not this is arbitrary, capricious, and whether or not the board is violating its fiduciary to you, it's violating the CC&Rs.
Yeah.
And at that point, the attorney can really assess, okay, what's the best way to approach this? Now, in California, it's typically not full-blown litigation. There's legal and economic sense, legal and economic realities as to why litigation won't make sense as a starting point.
Yeah.
So then you can contemplate maybe a demand letter, maybe start up the negotiations with the other side's attorney, not the board. Because when the attorney gets involved and sends an attorney letter to a board, it's going to likely introduce their lawyer.
Yeah.
And sometimes 2 adults can work it out.
Yeah.
If they have a good lawyer and that lawyer hasn't been weaponized, which we've seen historically, and we've talked about that. The more aggressive way would be not to start with the demand letter, because sometimes demand letters are an absolute waste of time. They can be. If you don't have the right audience, if you have a lawyer, an opposition lawyer who's consumed the Kool-Aid and has 100% just sided with the board blindly, that could be problematic. It happens. So maybe the better play then is ADR, which is the alternative dispute resolution strategy outlined in Davis Sterling.
Yeah.
And that can be a very forceful way to get the board's attention.
Yeah. Yeah, I do like that. I like that California does give some sort of like mechanism, and the whole purpose was to try to solve this outside of court.
Right. And then and if properly leveraged, ADR can be a very, very powerful tool for the homeowner.
Yeah.
But again, you got to be very strategic with ADR. But if you can get that in front of a mediator, a good mediator who sees it clearly, that's a win for the homeowner.
Yeah. I want to give a couple of examples of maybe a couple other red flags that might trigger an attorney.
Okay.
So, committee applies non-existent rules repeatedly.
Okay.
Committee refuses to provide written explanation. Procedural rights violated. No hearings, ignores timelines. Decision has no rational basis. State law protections ignored. So that would be like solar, drought tolerant, landscaping, EV charging, the specific things that are ignored in the state. Committee enforces rules not in any written document. So I think those, and then, one that we harp back to is they ghost you. They flat out ignore you. I think that's another one we like to add.
Or even worse, you get hit with a lawyer letter.
I think that goes back to the same basic framework. If they bring a lawyer to the fight, it's probably a good idea to at least talk with one.
At least talk to
yourself.
A lawyer, at minimum,
Yeah. Okay. There's a lot here in terms of just like financial harm. If you've already incurred if you already put a bunch of money into this thing and you train wrecks, they try to steamroll you, and there's a lot there. But I think we covered a lot of.
I think we did.
Gosh, we could
in one episode.
It feels like this thing we could easily squeeze out another 30 minutes.
You could do hours on this topic.
Because
it's endless.
It's a whole series right there. But sometimes you just got to pull the ripcord. I feel like now is that time.
Well, it'll be interesting too, and I encourage everyone watching the show, if there's more, if you want us to drill in on any of these topics, like the Reliance topic is quite big.
Yeah.
When a homeowner relies upon a representation of a board and they start a project, that becomes such a big dispute, or it can be, because the homeowner has already put in a bunch of money. Now, do they have to spend money unwinding the thing? Yeah,
and I learned a lot in this, in that boards can change the architectural standards, but they can't change anything in the CC&Rs. And if the CC&Rs are in conflict, there's a lot of nuance there a
lot of nuance, a lot of rules onto the rules, a lot of procedure. It's procedurally driven.
Yes.
If they're going to do something, they have to follow procedure. There has to be notice. There has to be this period of time where the community can speak up.
Yes.
Comment.
Yes. Yes. Yeah, we didn't even cover some of this stuff, but we can dive deeper. Comment. We can dive into very specific patterns. If this overview, and we need to dive deep and turn this into like a 3 or 4 part series, and that's what people want to hear, we put an avenue for people, which was our sub, for communication, for people to tell us, hey, it would be helpful if you could dive deeper into this, or do like a 3-part series on this, and we could break this down and go into it. It's so funny. We still have a lot of points in here that we could just continue to hit, but it's, this thing could go 3 hours long. It could go, some big time podcasts. Anyway, fun episode.
Joe Rogan style, right?
Yeah.
He goes for 3-4 hours.
Yeah. That's yeah.
All right. Well, thank you guys for watching. If you enjoyed the show, please like, subscribe, follow us on our subreddit, Bad HOA. Marty, thank you for joining us.
Thanks for having me, as usual.
All right. Till next time.